They came to my door at 7:15 on a Tuesday morning and arrested me for something a woman I barely remembered had told the police happened 23 years ago. I'd been a charity worker for most of my adult life. I had worked with young people in community programs, in school outreach, in summer schemes that ran out of church halls and sports centres, and underfunded youth clubs in parts of cities that everyone else had stopped paying attention to. I had given 31 years to that work. I had a clean record, a reference file, and the specific exhaustion of someone who had never once, in 3 decades, stopped doing the job because the job needed doing. The arrest happened on a Tuesday. By Friday, I had been bailed and was sitting in a solicitor's office, trying to understand how an allegation from 2001 had become a charge in the present, when I had not worked at the organisation the complainant named after 1999. The charity I'd worked for in 1999 kept records. Not comprehensively, it was a small organisation operating on minimal funding, but enough. Rota sheets, mileage claims, training logs, event sign-in sheets. My solicitor, a woman called Frances, requested everything that still existed from the relevant period. The organisation had moved premises twice, but kept their archive. The archive contained 12 months of records covering the period the complainant described. I was not present on the dates she had named, not absent without explanation, positively recorded elsewhere. A rota sheet placed me at a different site. A mileage claim placed me 60 miles away. A training log showed me completing a first aid course on the morning of one of the dates, in a room with 11 other people who had signed the same register. Frances put these documents to the Crown Prosecution Service at the earliest opportunity. They acknowledged receipt and indicated that the prosecution would proceed. The retention anchor is this. The complainant's account contained specific details about the building where she said the incidents occurred. She described the layout of a particular room, the colour of the walls, a specific piece of furniture. The building had been refurbished in 2003. The room she described had not existed in that configuration after the refurbishment. Photographs from before the refurbishment did not show what she described. The building as it had existed during the period she named did not match her account. Frances said, "She has described a room that did not look the way she says it looked. The records place you somewhere else. The CPS has both of those facts and is still proceeding. That tells us something about what they think this case is." The former colleague was a woman called Susan, retired youth worker, precise and troubled, who had worked alongside the complainant at a different organisation in the years following the period she described. Susan had contacted Frances after reading a brief local news item about the arrest. She said she had something relevant. She said she had hesitated before calling, because she understood the seriousness of both sides of what she was about to say. Susan had witnessed the complainant make a similar allegation against another worker at a previous organisation. The allegation had been investigated and not upheld. The investigation file still existed. Susan had kept her own notes from the period because the situation had disturbed her and she had not known what else to do with her unease. A previous allegation, same pattern, not upheld. The midpoint arrived when Frances submitted Susan's statement and the previous investigation file to the CPS alongside a formal request that they review the decision to proceed. The response came 12 days later. They declined to discontinue, Frances said. They are going to trial. She said it in the flat tone of someone who had expected this and had already prepared for it. The trial lasted 4 days. The prosecution's case rested almost entirely on the complainant's testimony, which was delivered with considerable emotion and considerable detail. The detail was specific. It was also, in several instances, inconsistent with the documented evidence in ways that Frances was able to demonstrate methodically, line by line, across 3 hours of cross-examination. The complainant had described the room. Frances put up a photograph from 2001. The room was not as described. The complainant said her memory of the layout might not be exact. Frances put up a second photograph. The complainant said the photographs might not show the area she was thinking of. Frances put up the rota sheet placing me 60 miles away on the date in question. The complainant said she might have the date slightly wrong. Frances put up the training log. The complainant said she could not account for that. The jury acquitted in 3 hours and 20 minutes. The twist arrived 6 weeks after the acquittal, when Frances received a formal communication from the Criminal Cases Review Body, noting that a review had been opened into the previous allegation, the one Susan had described, the one that had not been upheld, following the submission of new information from the trial proceedings. The review is ongoing. I do not know where it will go. I know that a woman made an allegation against me that was demonstrably inconsistent with the documentary record, and that the Crown Prosecution Service chose to proceed to trial anyway. I know that a different allegation against a different person made by the same complainant is now being reviewed. I do not know what the review will find. I know what I know about my own case. I know what Susan saw. I know what the rota sheets say. I am not in a position to draw conclusions for you. I am simply telling you what happened. You can draw your own.